Thank you.
Thank you.
Mr. Graham?
Thank you. May it please the Court. My name is Stuart Graham. I'm counsel for the defendant, Sokphann Chhim. This case is before you on the combined appeals. Mr. Chhim appeals from his conviction. Commonwealth appeals from the reduction of that conviction from first-degree murder to involuntary manslaughter. Initially, let me clarify for the Court Mr. Chhim's position regarding the appeal, because it's somewhat different today than it was in the reply brief, following extensive discussions with him. Mr. Chhim's position is that should this Court affirm the trial court's reduction of the verdict to involuntary manslaughter and affirm the Court's denial of his motion for direct verdict, then Mr. Chhim would waive the remaining issues and be satisfied with the reduction.
He'd waive the opening of the mail?
The motion to suppress
The
issues.
suppression issues
Yeah.
and the new trial issues.
Maybe you ought to send us a letter on that.
Yes, please.
A letter.
Yes, I will. Thank you. I will address first the Commonwealth's argument, or what I believe is the argument they will make today, and then address Mr. Chhim's argument on the motion for direct verdict. Rule 25b-2 allows the trial court to reduce a verdict to one most consonant with justice. This court reviews for abuse of discretion or an error of law. And in Commonwealth v. Woodward, this court noted that in a 25b-2 case, its review is quite constrained. The Commonwealth makes, I think, 4 arguments. The first is that the trial court let the ultimate sentence determine the level of offense. I think it bases that argument on the trial judge's statement that what Mr. Chhim did not deserve life without parole.
But the argument, I think, of the Commonwealth is that there must be some weakness in the critical evidence. I don't mean to state their position, but I'd like to ask you, what is the weakness in the critical evidence that you see?
In fact, Your Honor, all 4 arguments that the Commonwealth makes fall precisely on that issue.
That's why I asked.
Yes, the trial court repeatedly stated that even viewing the evidence in a view most favorable to the Commonwealth, which you do not do on a Rule 25b motion, the Commonwealth's evidence of malice was extremely slim and equivocal. Then the court said that taking the better view of the evidence, it doubted that the Commonwealth had proven malice beyond a reasonable doubt. Therefore, if there is no malice, or if that evidence is weak, the only offense left is involuntary manslaughter. The court's reduction was based upon the weakness of the Commonwealth's case on malice.
He said there was a single thread that allowed it to get to the jury?
That's correct.
Given the benefit, obviously, as he must, to the best light of the Commonwealth's evidence.
On his motion for required finding, he denied Mr. Chhim's motion because he said there was a slim single thread of circumstantial evidence that a jury could possibly use to infer malice. However, the court said that looking at this evidence and the better view, taking this trans testimony, who we believe was the only credible witness in the case, that Mr. Chhim left immediately after the victim turned away from him. He was not there for the remainder of the fight. The evidence was simply too equivocal to allow a jury to find that malice had been proven beyond a reasonable doubt.
Is it for the judge to decide, though, who's the only credible witness in the case?
On a Rule 25b motion, it is the judge's authority to do that.
Yeah, the judge is looking at the weight of the evidence, not the sufficiency of the evidence, right?
That's correct.
Yeah.
What do you do with the...
I'm sorry.
Well, over the past couple of years, as you know, we've had maybe 3 or 4 of these where there have been reductions by trial judges, and we've reversed every one of them, I think. Haven't we?
Yes, sir. I'm hoping we will break that trend.
All right. The standards are very, very elastic. You look at the weight of the evidence, is it consonant with justice, and so on. That's very, very elastic, is it not? It's akin to 33E?
It is. It is similar to a third degree and perhaps.
I can't remember a
the same.
case in the last 5 years where we've exercised 33E to reduce one.
Yes. In this case, I think the facts and the evidence are sufficient to uphold the trial court's reduction. In this case, we would argue later that the evidence of malice, we believe, was even insufficient to go to the jury.
Yeah, and I think the key point, one key point for you might be, and I know you stress it, is the judge has discretion. So if it's arguable, then I think you would say we have to defer to his exercise of discretion. And certainly it's arguable here on whether it should be murder one or manslaughter.
Yes, Your Honor, and it is within his discretion, and this court has indicated that its scope of review in a 25B is really quite constrained. The trial court heard the evidence. He evaluated the witnesses. He has the authority under 25B to review all of the evidence, to make credibility determinations, to consider the defendant's part of the case, and to make a judgment, in his view, what verdict, what level of offense is most consonant with justice.
But it's not enough to just allow the judge, give the judge discretion to substitute his discretion, his view of the case for that of the jury, is it?
Well, that's a difficult issue, because on the one hand, the court says, no, he's not just substituting his view for the jury. On the other hand, what the statute and the law does is precisely give him that authority. It's not, but he has to do it. He is somewhat constrained and more constrained than the jury. He has to look at the evidence and make a judgment of that evidence, all of the evidence, and then he says, what is most consonant with justice? The jury does not have either the obligation or the duty to do that. They're not instructed to do that. Only the judge can say, I'm going to determine the level of offense based upon my view of the evidence.
Except, I must say, I think, I'm not sure you should be phrasing it that way, because I think Roland, Commonwealth versus Roland, puts severe constraints on this well, I'm going to look at the evidence and figure out what's consonant with justice. There does have to be some weakness, some sense that, or some showing that the weight of the evidence pointed more strongly towards the lower level of offense, or some error in the trial proceedings that could have affected how the level of offense was perceived by the jury. There has to be one of those problems, not just sort of I don't think this person should go to jail for life, or, go to prison for life.
It's the difference between arbitrariness and discretion. Discretion is bounded by rules and procedures. Arbitrariness is not. A judge can't be arbitrary and just say, I don't think he should go to jail for life. In this case, this trial judge was extremely careful, was extremely considerate of the evidence. He viewed it and he said, the evidence of malice is too weak to support a first-degree murder conviction. He zoned in precisely on the weakness in the Commonwealth's case. And if you look at this case, the evidence of malice has to be drawn from the fact that after the victim turned away from Mr. Chhim had broken off the fight, distanced himself from what was going on, got in the car, there was that brief struggle, the victim turned away. That's when the circumstances changed.
So is this a motion for required finding?
There was.
Well, that was
Is that the standard?
No.
You said that the motion, that the evidence was not sufficient to support a finding of malice. Is that the standard that we should be applying?
No.
No.
I think what I said was...
Why should a judge be allowed to consider the sentence when the jury cannot do that?
Because the judge has two requirements. First, he is entitled to determine the level of offense. But secondly, the judge has a constitutional obligation under due process to ensure that the punishment imposed is proportional to the actions and the culpability of the defendant. And that's what this judge was doing. When he said he doesn't deserve to be in jail, life without parole, he's not saying, I'm going to let that sentence determine what the level of offense is.
So in 25B2 cases, is the analysis different than it would be had he been convicted of manslaughter?
The analysis on a 25B is always the same.
But you just interjected the concept of punishment because it was a mandatory punishment.
Well, I think what The judge's statement has to be understood in two ways. The first is, it's an expression of his understanding of the constitutional requirement of proportionality. He's saying, look at what Mr. Chhim did, and if we're going to impose a sentence and punishment on him, it has to be proportional. This conduct does not equate to first-degree murder.
You sort of jump over the fact there. Am I wrong? Didn't Mr. Chhim fight with the victim at the same time that the co-venturers continued to stab the victim?
The victim, once Mr. Chhim got in the car and the victim leaned in, there were a
Right.
few blows exchanged.
Okay, there was fighting. I mean,
Between the two of them.
Right.
There was no stabbing at that time.
But there was stabbing by the co-venturers at that
At some
time.
point, it's unclear when
Unclear.
the stabbing occurred, but it did not occur at the time that fighting began. That fighting began, and after that, there was some stabbing.
Mr.
And
Gray?
that's-
Right, but we know that
But-
the stabbing
but
is
there was-
going on while the victim is still leaning into the car.
Right.
Because we have this blood in the car and blood on this defendant, and
Well, we have,
So there is stabbing while the defendant is punching and his co-venturers are stabbing at the same time.
when Mr. Chhim broke off the fight, there was an assault and battery. And he was a co-venturer in the assault and battery. He distanced himself from that. He got in the car.
well, that's not exactly
Victim
distancing
leans
himself.
in. Victim leans in.
That's correct.
Defendant punches victim.
The victim
at
punches
the
the
same.
defendant.
Okay, and there's
comes
there's
back.
joint punching, and at the same time the co-venturers are stabbing.
At that point, the co-venturers come up and start hitting and stabbing.
Okay, so essentially that's right. While the defendant is engaged in punching the victim, the co-venturers are stabbing the victim.
But there has to be some basis upon which to infer the state of mind of Mr. Chhim to engage in something more than an assault and battery. What was his state of mind? What was the malice? And that's what the court said. The evidence of malice is just insufficient.
Well, it's-
let me
the
rephrase it. Malice is too
Mr.
weak
Gray-
to support first-degree
Mr.
murder.
Graham, the difficulty with which the judge struggled in a very thoughtful way was the following. This was not felony murder, right? This was a joint venture for murder on a theory of extreme atrocity and cruelty, correct? And he tried to fashion jury instructions, which were not specifically addressed in our model jury instructions on that point. Very difficult. And what he said is, and I'll ask the Commonwealth, so you may as well begin to think of the answer, did the judge correctly frame the question as whether Chhim shared the intent necessary to permit him to be found guilty of being a joint venturer in a murder committed with extreme atrocity and cruelty? Now, I haven't looked at the evidence in this trial, but I know very well the evidence as it was developed in two co-defendants' trials, right? I mean, I happen to have done the 33E, and Justice Graney's done the other one. So you've got two justices who actually know a lot about the events here. And as I recall the evidence, and I have not looked at this trial, is that there was a fist fight. There was a fist fight. This defendant left the fist fight and got into the homicide victim's car, which was a short distance, but a distance away, in an attempt to leave.
That's correct.
Correct? The victim, who was then still alive, realizing that his car was about to be stolen, went over to the car, correct,
That's correct.
and leant in, attempting to stop this defendant from driving the car away.
That's
Am I correct?
That's correct, Your Honor.
And what this defendant was doing was pushing him out of the car so that this defendant, could get him away, correct?
That's correct.
And while that happened, the co-defendants followed the victim, correct?
That's correct.
And continued to beat him, correct?
That's correct.
And as it turned out, subsequently, one of them, not the one sitting in the car, had a knife and stabbed him,
That's correct.
correct?
That's correct, Your Honor.
So the question that the judge is struggling with is this sufficient to sustain a conviction of joint venture where you have to establish that he had the intent, this defendant had the intent necessary to be a joint venturer to commit murder with extreme atrocity and cruelty.
That's precisely correct. Your Honor.
Right, but he lowers it all the way down to manslaughter, so he has to also consider whether it's a second-degree murder,
Correct.
whether there is malice.
Yeah, he lowers it to manslaughter because the difference between murder and manslaughter on third-pronged malice is really the degree of risk that a reasonable person would understand was created by the conduct based upon what the defendant knew. The
I must say,
focus is
everybody
on what
seems
he
to
knew.
assume that you leap immediately to third-pronged malice. What's wrong with second-pronged malice?
Exactly.
Intent to inflict serious bodily injury.
The judge,
I mean, everybody always seems to make the assumption that we have to look only at third-pronged malice.
I'm sure the
Why
judge
couldn't
looked
you
at
infer that here?
because looking at what Mr. Chhim did, he had a fist fight. That was it. He then broke
Well,
off
that's
that
intent to
fist
do
fight.
grievous bodily harm that results in death.
I'm sorry, Your Honor?
That's intent to do, no question this defendant intended to do grievous bodily harm. This was not, this was
Yeah,
This
the victim
was
was
a conflict
outnumbered.
where 4 men, I think, or 5 men, I forget, left a car and jointly went to pummel this man.
And they said it lasted about 5 minutes with punching and kicking while the victim
was
on the
pretty
ground.
serious stuff.
Why isn't that enough to infer second-pronged malice?
There are different phases in this, Your Honor. Mr. Chim's action, he threw a couple of punches and left. He broke off the fight.
No,
he
but
got in the
don't
car.
characterize it, at least for this justice, as a couple of punches.
That was the testimony, Your Honor.
Well, I'm saying that the trial judge was there. The trial judge very carefully weighs all
As
of
I
this.
said, I
But
haven't
I
read
don't
this
think he read
since.
this part with all due respect. He was focusing on the instant of stabbing and what was this defendant's mental state at the time of the stabbing. He doesn't, as I read it, it's a very careful discussion of that precise moment of events, but it does kind of gloss over the potential for second-pronged malice. This is sufficient for second-degree murder, probably not first, but second-degree murder in the original 5 minutes of 4 guys against 1 bad beating.
I think, Your Honor, it wasn't. The testimony actually is different from that. There wasn't 5 minutes of beating at that time. There were a few punches thrown. Mr. Chim left. The time that you're talking about when he's on the ground, that occurs after Mr. Chim either left or was sitting in the car.
No. Well, I should read it again, but it's my understanding there was a significant melee already underway before Mr. Chim left and got into the car.
According to Ms. Tran's testimony, who was the only eyewitness to this, they got out of the car. 3 of them were facing the victim. 2 others went with Mr. Richardson. Ms. Tran testifies that the fight starts. Mr. Chim throws a couple of punches. That's her testimony. He then leaves and tries to leave the scene just as
Well, let me
he's-
ask you-
But so when does this
Can I
5 minutes
I
of
just ask
beating
you-
take place? Because
That happens
then if he was
afterwards.
leaving the scene, he would have had plenty of time to drive off.
Let me
happens
put it,
afterwards,
Mr. Graham, could I ask you this
By then he's already
specifically?
been stabbed.
Yes, ma'am.
I'm looking at the Commonwealth's brief, right? And what it says, and tell me whether or not this is consistent with your memory of the testimony. The defendant and 2 others fought with the victim near the victim's car. The defendant punched the victim a few times, while the other 2 punched and kicked him. And then the Commonwealth says, this relentless beating continued for about 5 minutes, at which time the defendant jumped into the driver's seat of the black Honda.
Okay, I think that is not a correct statement of the evidence.
Okay.
Ms. Tran testifies that the time between after Mr. Chim got in the car to the end of the fight was about 6 minutes.
Then
Mr.
if Mr. Chim was leaving the scene, 6 minutes gives him plenty of time to drive off.
That's correct.
Okay, so
Ms. Tran testifies, in fact, he did drive off immediately. There is other evidence.
But not until after, obviously, the altercation through the window
Well, we
and
obviously-
the start of the stab.
Mr. Graham, we can't solve the whole thing in 20 minutes. There's 15 volumes of transcript here, correct?
That's correct.
All right.
Thank you, Mr. Graham.
Yes, thank you.
Mr. D'Angelo.
Yes, sure. Thank you. May it please the Court, and good afternoon. My name is Peter D'Angelo. I'm an Assistant District Attorney in Middlesex County. I represent the Commonwealth in this appeal, and with me is Assistant District Attorney Kevin Ryle, who was the trial attorney in this case. It is the Commonwealth's contention, and I think as my brief sets forth, that Justice Gantz, although he purports to take the evidence favorable to the Commonwealth, and I know that's not the standard under 25b2, he can pretty much pick and choose as he likes, Justice Gantz doesn't do that. Tran did testify in this case quite clearly, and I mean, I reread her testimony last night because I felt it's the most crucial testimony. He thinks it's the best testimony. It's a testimony certainly to focus on. She states that, look, there was a fight. This is over a parking spot in Lowell on Cross Street. The defendant was outnumbered. It was 5-2, the victim and his friend, and 5 co-defendants. 2 of the co-defendants go off with Mr. Richardson. This victim faced 3 defendants, one of which was this defendant. And Tran testified approximately, she says 5 minutes less is the exact way she phrases it. There was a fight. The 2 co-defendants that faced off with the victim were kicking and punching the victim. The defendant was punching the victim. Even the defendant states in an admission to police officers that, yes, he had struck, although it's not clear at what part in the fight, he does say he struck the victim several times.
Mr. D'Angelo,
Yes, Your Honor.
and again, forgive me because it's always complicated when you've, he wasn't, this defendant wasn't, this isn't the same trial as the Bolchern.
This is the same case.
No, I know it's the same case.
The 3 guys,
Okay,
the 3
so
gentlemen.
So first of all, I've got different evidence here,
Okay.
so forgive me because of,
It gets
you know,
confusing.
but was there evidence in this case that before this defendant got into the car, into the victim's car, to drive it away, purportedly to drive it away, that the stabbing had begun?
Before he got into the car. No.
No.
Okay.
There's none. There is something that Richardson says, I do note it in my brief, and again, Richardson said, my friend got poked with something, and he let out a loud cry. This is the very beginning of the fight. And he said, well, what was it? I don't know what it was. I didn't see it, but I thought it might have been a sharp object. He didn't see it, but his friend, the victim, Carlos Doty, who died in this case, did let out a pained scream. So there's some evidence. Again, if you want to take the light favorable to the Commonwealth, and that's what Justice Gantz does. I know what the standard is, but he pretends, I don't say pretends, he sets out evidence in the case and says this is favorable to the Commonwealth, and it's really not. It's some evidence that there was a little bit of a tussle, defendant gets in the car, the victim...
No, that's why I said there was, at least my memory, and again, forgive me because I haven't read this transcript, there was a very serious, deliberate beating. I mean, it wasn't... I mean, these men got out of a car and jointly went, and there was nothing to suggest that there wasn't pretty quickly, you know, pretty hard assault and battery. I mean, pretty confrontational assault and battery.
There was a battery before the stabbing. There was the stabbing, and depending on whose testimony you believe, when Justice Gantz decides to really Sharon Shea, who was just a person who lived on Cross Street, called 911, he thought the cars left at the same time in tandem. Jeremy Richardson felt he was the victim's friend. He was fighting with 2 other individuals.
I thought he was around the corner at the time.
Mr. Richardson, he was, but he had come back, or he was standing there when he claims to have seen both cars drive by. So 2 witnesses do say the cars leave in tandem at the same time. Tran didn't think so. Tran's recollection was that the defendant left after the stabbing. But part of the problem, and Justice Gantz, he says, well, there's no evidence the defendant in this case actively participated because, well, there's no evidence that he held the defendant to, that he held the victim so that the victim could be stabbed. And that's really not correct. I mean, this is Tran's testimony, and that's what I cite in my brief, because she's really the person right there who's watching the altercation. And she says, look, there was a 5-minute fight, and then there was a 2-minute struggle at the car door, approximately 2 minutes, with the victim leaning in the car, and they're exchanging blows, the defendant and the victim. At which point, the knife comes out, and there's at least 5 stab wounds or less. That's her testimony, 5 stab wounds, comma, less. That's an approximation on her part. And there was this blood in SRA 18 in my supplemental record.
Remind me again, some of the stab wounds I know were to the back of the victim.
That is correct, Your Honor, they were.
Were all of the stab wounds to the back?
There were a number of stab wounds to the back. I mean,
And I know there was
one
some
to
to
the
the
front.
And what was this fellow doing at the time the knife came out and the stabbing started? What exactly
According
was
to
he
Tran,
doing
he was
according to
struggling
her?
with the defendant,
Pardon
struggling
me?
with the victim.
To get him out of the car.
struggling with him, fighting with him.
Defendant was in the car. Victim
Defendant's in the car.
was reaching in the window.
Just to stop the defendant from stealing his
Right.
car and his method of escape at the time.
And he was stabbed from behind by
Not from behind. He was stabbed under the side, to the right
You
side.
said almost all the wounds were from behind.
They were, the wounds, there were wounds on the back and on the side, the right side. The fatal wound was under the right nipple.
And do we know when that occurred?
Justice Gant says, because Mr. Chhim took off at that time, if you believe Trent, he couldn't have been there for the fatal wound. I can tell you that in this transcript, that's clear error. We don't know when the fatal wound was inflicted, and I think Mr. Ryle throughout the trial said, we don't know. There's an inference that it was inflicted when the victim was through the window, because there is just a lot of blood. If you look at that SR-18, that window is caked in blood. I mean, it's not a splatter. It's pretty gross. There is blood all over that window. So I would suggest that, and Trent says he's getting stabbed in underhand fashion from the right side. So it's certainly within the realm of, I think, of reasonable inference that that's when that wound was inflicted. Can I prove that? No. And I certainly know Justice Gant can't state the defendant wasn't present when the fatal wound was inflicted. I think he says almost certainly not present. And that's how Justice Gant, again, I think, when he takes this evidence, he really just, I hate to say it, plays that 13th juror that this court has admonished not to do under 25b2.
Wait a second. There are different analyses here. I mean, we know that it's not a question of whether the evidence is sufficient. The judge found that it was sufficient to go to the jury on this question.
Barely.
Yeah, but it's a question of the judge looking at the evidence and the weight of the evidence, which is a different measure. And in that respect, he doesn't have to take the case as the Commonwealth views it. He can take the case as a whole as he views it.
I understand that, and he certainly could do that.
Mr. D'Angelo, I take it from what you've said, though, that, and I'm going to read from the judge's characterization. Now he's getting down to how he's going to apply, which he correctly lays out. I mean, I don't have a problem with the law as he lays it out. That when the defendant, and I'm substituting defendant and victim here. When the defendant entered the victim's Honda, and now I'm reading, the fight with the victim remained simply a fist fight, and there is no evidence that this defendant knew at that time that a second defendant would pull a knife and use it to stab the victim. I take it when you said he's clearly wrong, that's what you're talking about.
No, when I was talking about him being clearly wrong is where he thought the fatal wound was struck. In terms of whether or not the defendant knew there was a weapon, there is some evidence, indication, and I noted in my brief, that Richardson did say he thought a sharp object had been interjected into the fight at the very beginning.
Isn't the simpler way, it seems to me, of addressing it is, did he have knowledge that the stabbing was going on while it was going on? And certainly you can infer that, if from nothing else, from the volume of blood.
The blood on his pants,
on his pants,
on the passenger seat.
It's suddenly coming into the car.
In the car. Exactly.
So if he is still participating in any form of
Assault
with the victim at the time he knows the victim is being stabbed, if those two time periods overlap, there is, inferably at least, evidence of malice.
Exactly. You can't, I mean, it's not one stab wound. It was five.
Right. But can the judge, however, looking at the weight of the evidence, say that that overlap is potentially so slim in time as to be equivocal about whether there really was malice at that sort of precise moment?
He might be able to, but he didn't in this case, in the sense of he just ignores it. I
The
mean,
defendant was seated in.
I'm sorry.
Defendant was seated in the driver's seat. Is that right?
That's correct, Your Honor. Yes.
And the victim is leaning in the driver's window.
Yeah,
And there's blood found on the passenger side. How much blood is on the passenger side?
His DNA was found on the passenger side, and there's a blood smear. And again, all my SRA, all the pictures and exhibits, I took the time to copy them. Because, and Justice Gantz, by the way, you wouldn't know there's any blood on the car at all, from his opinion. He doesn't mention, he talks about, I think, a splatter, or he doesn't mention the amount of blood. I mean, if you have a man in your lap and you're punching him while your friend is inflicting 5 knife wounds, and you get blood in your pants and blood all over the area that you're punching this person, I think that's a strong and compelling inference that you possessed malice at the time. In the 2 cases that are on point, we relied on Samato and Johnson below, which was that unfortunate tragedy in Dorchester.
Well,
at the
again, I'm sorry. Again, I'm just looking at that point, that what the judge is saying, and I assume that he's looking at this evidence pretty carefully is that, to go back to Justice Sosphan's question, and again, we just have to look at what the evidence is, he said that it is not clear from Chhim's testimony as to whether this defendant continued to punch the victim once the stabbing commenced.
I believe Tran, my recollection of the testimony, and it was that it was still going back and forth. I think Tran said they were still going at it with each other while the stab wounds until he pulls out of the car.
Why did this defendant jump in the car? Was he trying to move it?
Couple reasons. The whole thing started over a
Well, I know it. So he was trying to perhaps move the car?
Move the car. I mean, if the victim wouldn't move it, because him and his gang
And
just
then the
told him to
victim
move
decided he's going to try to get him out of the car.
Well, it was a brand new car. It was 2 days old.
Right.
I think the defendant was, I don't think the defendant was certainly leaving the scene because, oh, God, this was getting distasteful to him. I think he was going to move that car because the victim wouldn't do it.
But at that point, the stabbing starts.
At that point, the stabbing starts because, I mean, also, too.
And at that point and after that point, the defendant just stays in the car.
Well, the victim unfortunately was put in a precarious position because this defendant decided to steal his car.
Well, correct.
It revoked a response, and he's fighting three guys now with the defendant, and those two guys were giving a clear opportunity to put a knife into him because he had to deal with the defendant.
But the defendant's just in the car, and all he had done up till that time was engage in an assault and battery with a bunch of other people.
Right.
Right. And he stayed in the car.
He stayed in the car and helped.
And he didn't jump out and try to restrain.
5 knife wounds.
Pardon me?
I mean,
Yeah.
He was struggling while
But
those knife
according to
wounds
the
were-
evidence, that's the first time the defendant realizes somebody's got a knife.
And at that point, he's continued to struggle. The victim's continuing to bleed everywhere. He needed to, at that point, really, I mean, there's really nothing he can do. He can't stop or abandon. He's put himself in. He has committed himself at that point to this venture. And he drives off after, but I don't think that absolves him of the
Are you
case.
saying the defendant, when the victim is struggling with him in the car and they're getting stabbed, is somehow assisting in the stabbing by holding the victim?
Sure. Yeah, sure. I mean, if you're fighting with someone, it makes it a lot easier to someone to stick a blade into you. I mean, I think, I've never had it happen to myself, thankfully, but I certainly believe that.
The question is, I think a lot turns on, he gets into the car. So from his point of view, he's left the fight. And I know it's not your, but from his point of view, he's left the fight. He's no longer continuing to engage in the fight. He gets into the car. The victim approaches the car and tries to get him out of it, correct?
Yes, right.
Okay.
Tries to, I don't know if get him out of it, tries to stop him from stealing his car.
Keys in the ignition.
The car was running, my understanding
Running.
was,
Mm-hmm.
at that particular time. And part of the problem, I think, with Justice Gantz, and when you read his memorandum and you look against the facts, and I think that's what sort of upset us, but I think when I started to say this could be a problem, is that he really just glosses over a lot of the facts. And what really bothers me is he says, I'm taking the evidence favorable to you, Commonwealth, to show I did everything I could do in this case, but justice under 25B2 required me to reduce it.
I mean, he deals very directly with the required finding motion. This is after the trial. What do you think he glossed over?
The struggle in the car and the 5 knife wounds. I mean, it's not clear that Justice Gantz is
And
not
all
clear.
the blood that
And all the
resulted.
blood. That's a lot of blood.
That's the critical point, isn't it? What happened? That's the critical
I think so.
time
Yes.
when the defendant is in the car and the victim is attempting to struggle with him to either get him out or whatever, and they're going at it, and he gets stabbed. That's the critical point. Up until then, you don't have much participation in a murder by this guy.
Right. And that's correct. And Justice Gantz just seems to say there was a fist fight, he walked into the car, a little bit of a struggle, and he drove off. And if that were true, then yes, all right, I see his point, but there's a little more to it. And we tried to explain to the judge when we had the hearing on the 25B2 motion was, look at this blood evidence. The jury saw this. I mean, you can't say, I didn't participate, I didn't do anything.
Well,
the blood
you've got
evidence-
blood on your pants.
Mr. D'Angelo, correct me again. And Judge Gantz says that there was evidence in this case that this defendant is sitting in the car. He's watching as the two other co-defendants continue to assault the victim. They then chase the victim around the Cadillac, which was the other car.
After he pulls out. My understanding is after the victim pulled out, after being stabbed a few times, he tries to get out because he knows he's in trouble, and he starts to run away from these guys, and an additional fight continues. And at that point, allegedly, according to...
Well, as I understand, the evidence in this case is that Judge Gantz is saying that the fight continued and so when did the victim lean into the Honda in relation to when he ran around the Cadillac?
It was
before?
after.
After?
I believe that would have been
So,
after.
so that he's,
Which is after which?
Yeah. The run around the Cadillac is after the fight.
After he's been stabbed.
Right.
After
no,
he's
no, no.
been stabbed.
When does he lean into the car? Is the run around the Cadillac
Is
before
after he
or
leaned
after?
After.
After. That was my memory, but it was after.
Just a practical question. Was there a transcript available to you and the judge when this motion was heard? 6, 7 months after?
I don't believe so, Your Honor. I mean, I think we took copious notes, and I know Justice Gantz, his facts aren't so bad, but like I said, when he does the analysis, it becomes a question of, he just to me leaves out a number of items.
And I take it the transcript is available now.
It certainly is now. Yes, it's a very good
15
read. It's a very
volumes.
long read, but it's a,
Yeah,
like
3
I
years
said,
later.
It's a very good read as well. If there are no further questions,
Thank you.
Thank you, Mr.
thank you,
D'Angelo.
Your Honor.
We'll take a short break.